Alright, so moving on, we just completed number 1. Now we go to number 2, which is the second ruling. Number 2, that the conviction be set aside and a new trial takes place if the newly presented evidence substantiates a retrial. Full stop. And again, just to remind you, if the appeal is at the Court of Appeal, they can order a retrial to the Court of Justice. But if the appeal is at the Court of Justice, then they can be a retrial there and then at the Court of Justice at a later date. Number 3. That the accused be acquitted That's number 3. Did I say that? Number 3. That the accused be acquitted if the newly presented evidence shows that the accused is not guilty of the offence. Okay, number 4. Criminal trials can be heard before a judge and a jury or before a judge alone. Full stop. For trials heard before a judge alone, and the accused is found not guilty, there is an option for the Crown and by the Crown, because Canada is still part of the Union of the Commonwealth, then trials are generally undertaken in the name of the Queen in this instance, or King, whenever she decides to step down. And because of course she plays no part other than a figurehead, really. It's not the Queen personally who accuses. It's just generally referred to as the Crown. So the Crown is the representative basically of the figure-headed Queen or the figure-headed King, if ever we do get a king, whenever we do get a king. So generally you will have, for example, the Crown versus whoever it is. Or in the old days it used to be Regina versus whoever the accused is. And in this case, the Crown basically is represented by the Crown Attorney or the Crown Prosecutor. So when we talk about the Crown, it just really means the figure-headed Crown in terms of the Crown Prosecutor, which again we will see in more details in Module 2. So, just to repeat, for trials heard before a judge alone and the accused is found not guilty, there is an option for the Crown to appeal against the acquittal or to appeal against the level of sentence. Full stop. In such appeals, the appeal judge can overturn the previous not guilty verdict provided that the evidence presented by the Crown is sufficient to justify such an overturn. Full stop. The previous verdict of an acquittal will be overturned and the appeal judge will find the accused guilty then sets a sentence. Full stop. So basically, when one appeals against a conviction, they can have the appeal dismissed, meaning they can lose the appeal. They can have the conviction set aside and a retrial is ordered, or they can win their appeal and the accused is then acquitted. And finally, if the verdict was a guilty, or not guilty rather, if the previous verdict was not guilty, the Crown has an option to appeal. In other words, if they have sufficient evidence, probably now, that they didn't have previously, to secure a guilty verdict, and at the previous trial the accused was found not guilty, now the Crown has new evidence, they can appeal against that previous not guilty verdict. And provided that evidence is sufficient, then the accused can be dragged back, is found guilty, and is then sentenced to whatever the sentence may be. But this is this is a rare occasion, and it happens only when you have a judge sitting alone. In other words, where you don't have a jury deciding the verdict, you have the judge listening to the evidence, you have the judge deciding the verdict, and you have the judge passing a sentence. then provided the Crown has new evidence to present, they can actually appeal or be granted leave to appeal in that situation. Because just in case there is there's a likelihood or a slight chance that the previous judge may have been too heavy-handed or whatever, as he's the only one making all the decisions, then the accused is given reconsideration in terms of the Crown being able to make presentations and to justify that the accused should be found guilty. So you can have 4 judgments, 4 rulings from an appeal. Now, in addition to appealing against a conviction, we can also have an appeal against a sentence. So the next heading now is appeals against sentence. New paragraph, if the appeal is against a sentence, the appeal judge can reduce, increase, or substitute any previous sentence. Okay, full stop. So basically, again, to appeal against a sentence, the appellant runs the risk of having the sentence increased, or of course it could be decreased, it could be reduced, or there could be a whole new sentence substituted. I remember some years ago there was an appellant, and he felt that his 3-year sentence against rape was far too long. So he appealed, and the judge doubled it to 6 years, which probably one of the only times that we applauded a judge's decision, but it does work in some cases. So here we have now an access to further justice from the court system, because we now have a system of an appeal. Now, when we come back from the break, we are going to have a little break because this completing form is going to take us a little bit beyond. So when we come back, you should have a notice of appeal form. There. Notice of appeal. This one is from Alberta, and it's from the provincial court. So we're going to be getting our appeal, notice of appeal form. When we come back from the break, we shall complete it. So see you in just a minute.